Merci beaucoup, Professor Sirinelli. I'll switch to English also to do a better job. I'm incredibly honored to be here. I've been studying and working on copyright for 2 decades, and I have wonderful panelists. It's an honor for me to be here and to be able to summarize 28 national reports. I know that there has been another report being uploaded by South Africa, and I was not able to work on it, but I'll try my best to summarize all the major trends. What I've tried to do in the slides that I will use is essentially a summary where I'll try to hinge on the most important points and trying also to reflect the diversity of the reports. As I said, we received 28 reports, 29, one is upcoming. The overwhelming majority of these reports came from European Union countries. There are 3 reports coming from countries that are linked in a way or another to the European Union. If we think of the UK, when it comes to Brexit, we understand the influence of European Union law. And I'm saying this although most of you know the origin of the report, because the influence of the European Union is pretty clear on digital policy issues. That's the reason why, and that's why I think there is a broad homogeneity, at least among the European reports. Then we have 2 countries from North America, Mexico and the United States, 2 countries from South America, Argentina and Colombia, and 3 countries from Asia, Japan, Korea, and Singapore, and 1 from Oceania, Australia. The questions that were addressed in this report are essentially the ones that you see in the slide, especially when it comes to the applicability of the exclusive right of communication to the public and whether or not this right is exclusive in a way that it can be considered self-sufficient for the rights clearance, and the overwhelming majority of the reports, as we will see, says that it's not sufficient because it's normally backed by the clearance of the reproduction, or as it's called in the music sector, mechanical rights. And then obviously there is a question about how authors and performers as individual right holders concretely benefit from this right. As regards to transfer of rights, it's been analyzed in this Congress. Yesterday there were excellent presentations about it, but in this part of the questionnaire, there was a specific question regarding the possible presumption in the transfer of online rights from the individual right holders to the, let me call it, corporate right holders, the entrepreneurial right holders. And we will see that there is a sort of variety of views. The third point, which is kind of interesting even in Europe, but even in North America to a certain extent, is how the authors and performers are remunerated, and if there are residual right to communication to the public for the aimed at remunerating them that go beyond exclusive rights. We heard about them yesterday. I will try to briefly summarize the situation when it comes to these rights around the world according to the reports. Then we have the important issue of collective rights management. When it comes to streaming, is it voluntary? Is it mandatory? For which rights is it mandatory? Or it's extended according to the Northern European tradition? And what is the role of collective management when it comes to the potential residual right to remuneration? Last but not least, it's a kind of intriguing question, which is probably one of the most important to resolve some conflicts between especially between the right holders. When Professor Sirinelli was speaking about the unity of the right holders, for instance, in the music sector, it's a vexata quaestio, I would say, using a Latin expression. And here it's mostly the principle of transparency when it comes to the revenues collected by streaming platforms. And here I would like to use a broad concept, at least in our project Fair MusE, we use a notion that embraces, unsurprisingly, social media, social media services, especially after the implementation at national level of the famous Article 17. And there was a very narrow but intriguing question regarding whether or not an obligation to notify updates in the management of rights, as it happened in a US case concerning Eminem's music, Eminem's publisher, exists in the countries where the reports come from. And we will see that it doesn't exist, and in the US it was a very specific consequence of the way Eminem and his publisher brought the suit against Spotify. Very briefly, we can say, according to the reports, that the harmonization at international level of the right of communication to the public meant as a right to make content available has been broadly implemented, has been successful. So the conclusion we can reach is that, yes, these treaties, for which we have eminent witnesses and protagonists here, were successful. There is a very big exception to this trend. I'm sure Professor Ginsburg is never tired of emphasizing this. The United States nominally do not use this right even for the online environment. They use a combination of public performance and reproduction right, even though commercially speaking the result is very equivalent. As I said, the communication to the public right as a right of making content available is not self-sufficient. In all the countries that the reports are about, the reproduction right in the music sector, where the reproduction right is distinct from the right of communication to the public, is complementary and necessary. And this is evidence in the practice of collective rights management for authors and publishers' rights around the world. There is a consolidated practice regarding the licenses of both rights, with the consequence that the revenue are to be allocated to distinct right holders in this sector. Well, here, when it comes to the transfer of rights, we already heard that especially in the reports coming from continental Europe and the civil law tradition, there is a concern regarding the potential vulnerability of authors. So we do have limitations to the transfer of rights. But here the questioner was very interested in understanding whether or not, when these new forms of exploitation came out, whether this could have been regarded as a new right or not. And here the answers are quite different from each other. And I would say that at the end of the day, this is also reflected in the way they legislated in this field. When it comes to presumption of transfers, even in the digital domain, it's rather evident from the reports that in the audiovisual sector, there is a stronger tendency to consolidate the rights in the hands of the producers, whereas when it comes to the music sector, the presumption in favor of the record producers tend to be narrower and are nearly always, nearly everywhere absent or rebuttable at least, leaving performers, music performers with a better bargaining position, at least from a collective point of view. When it comes to remuneration of authors and performers, freedom of contract unsurprisingly prevails in common law countries, or in countries where traditionally this is the way to negotiate the clearance and the transfer of these rights. The European reports obviously show the existence of a subset of rights to remuneration that persist after the transfer or licensing of the underlying exclusive rights, and this is the case of Belgium, Croatia, Hungary, Poland, Portugal, Switzerland, even though in each of these states the conditions of applicability of this right change. So there is no harmonization. I can tell you that if Spain had submitted a report, I would have included Spain too. And Spain is the country that has had, at least in the European Union, this right for the longest time as a result of the implementation of the Information Society Directive. But again, these countries provide this right, but the conditions change, and so it's impossible to design a sort of precise model. In the music sector, we also heard about it in South America. You probably remember also the case of Uruguay, that is not among the countries that submitted a report. But in the vast majority of statutory remuneration rights concern online exploitations of performances, especially in the music sector, for the simple reason that when it comes to authors and publishers' rights in the music industry, there is deep management of CMOs. We know that now we have specialized independent management companies. CMOs have become data companies. They form their own joint ventures. So it's very much an exclusive right-dominated sector of licensing. And then we heard yesterday about the general principle. Frank Goetze used this expression of Article 18 of the DSM directive. All European countries mention this, even though we know that the implementation has been different, and so there cannot be harmony yet in this domain. When it comes to collective management, it's predominantly voluntary or contract-based, again, unsurprisingly in jurisdictions like the UK, US, Australia, Singapore. From the reports, collective management tends to be mandatory, especially for the residual or equitable remuneration rights that I mentioned a few instances ago, in Belgium, Croatia, Hungary, Poland, Portugal, Romania, Slovenia, and Switzerland. And I might have made some, mistakes not, but I mean, there is a kind of diversity that I already emphasized, so keep it cum grano salis, as Latin said. When it comes to extended collective licensing, we are all fascinated by the system of the Nordic countries. The reports submitted by Norway, Denmark, Finland, and Sweden are reports that clearly show a potential for ECL, but at the same time, even the Nordic countries in Europe had to follow the model that was in many ways imposed by the European Commission, which instigated this competition between collective rights management organizations, each of which these days in the online environment represent a single repertoire. So ECLs would be at odds with this system of repertoire-specific licensing. That's the reason why they are not used, even though there is a potential, especially for cultural heritage work and educational materials. But again, it's a sort of sector reserved to licensing and based on exclusive rights on a sort of voluntary basis, even though from a market perspective, very often the right holders do not have a choice because they have to resort to the hubs that have been formed in the last 15 years. Then obviously the United States is always on its own in this because it's in many ways self-referential, so exceptionally big market. We know that there is a system that is hybrid. We know about the collecting societies in the US, especially for the musical compositions. And we know that from 2018, even though it entered into force in 2021, Music Modernization Act created a blanket licensing system for the reproduction rights in musical compositions, creating also a licensing collective that is supervised by the Library of Congress, and this is a system that also aimed at avoiding the catastrophic statutory damages that the platforms, the streaming platforms, not the social media, were exposed to, as the Spotify cases are showed. But interestingly, and you probably know that for the US, the performance rights from 1995 are administered under statutory license by Sound Exchange that helped the performing artist sector significantly in the US. Transparency. We do have Article 19 of the European Directive from 2019, the so-called Digital Single Market Directive. All the European reports acknowledge the influence of this provision. These provisions generally require annual reporting detailing the revenues, modes of use, and the derived remuneration. This means that, in a way, the prescriptive force of this provision worked. Then obviously we have to see the results. The results are still unclear according to the project I'm leading. I would say the best is yet to come in a way. But otherwise, when it comes to other countries that submitted reports, transparency relies mostly on collective management organizations' governance rules. This is the case of Argentina, Colombia, Singapore, Australia, or statutory licensing regimes. This is the case of the United States, historically, where the collecting societies have been subject to scrutiny through this statutory regimes that, and a sort of competition-driven, antitrust-driven control that is pretty historic. In the EU, I would like to add, even though some reports hinge on this aspect, that we do have, even before Article 19 of the 2019 directive, very prescriptive provisions incorporated in a directive that was adopted in 2014 on collective rights management, with a chapter on online music licensing of musical composition rights, which introduced transparency and reporting obligations for CMOs towards their own members, unsurprisingly, other CMOs and users. And I would add, this directive also made it mandatory for the streaming platforms, and I would say even the social media services, a level of transparency that these services, especially the social media platform, never achieved. So Article 17 of the directive is also helping the music sector in particular to make these exploiters more accountable in a way. So let me conclude on this. Transparency, in a way, has become the new frontier of copyright licensing and enforcement. The problem that we see is that, this is a little bit like my last slide, there is a sort of inequality in the way the principle has been implemented. A very specific question was asked in the domain of large music catalogues. And here there was a specific reference in the questionnaire to the Eminem case. It's not Eminem himself, it was his publisher, 8 Mile Style, that filed suit against Spotify. It was a litigation that spanned over a few years, and it was settled last year. And it was basically, it was the publisher of Eminem that sought damages. It was statutory damages, very lucrative damages from Spotify, because Spotify erroneously got a license for the mechanical rights in the 8 Mile Styles compositions from the wrong administration, Cobalt, because Cobalt in 2011 had transferred this function to another administrator without notifying Spotify. So what the judge found in the first instance is that it was opportunistic from the music publisher to wait a few years. This is the conclusion that obviously the publisher contests vehemently. It waited a few years to be able to recoup damages, statutory damages that would have been more lucrative in terms of financially than the revenues that Spotify would have paid, which is kind of interesting. If it is more convenient to it signals in a way that the statutory damages are probably exaggerated, but it also signals that the revenues are not probably enough, I would say. My conclusion on this specific front, we don't have such a obligation of transparency, and this is something that all the reports signal. Most of the reports signal that there is no litigation in this regard. Only Croatia signaled a pending litigation promoted by HUZIP, the performance organizations. But I would conclude by making a reference to two important pieces of legislation that obviously are factored in the reports: the 2018 US Music Modernization Act and the EU Directive on Collective Management from 2014. because both of them, in a way, contain the principle of transparency. The first, in the US, it imposes basically all, the collection of all the data concerning the reproduction rights in musical compositions under the supervision of, indirectly, of the government. I mean, Library of Congress, you know that these days is controversial, but it's part of the US administration, so there is a scrutiny that is ultimately in the public interest. And in the directive from 2014, we do have, for online licensing, a mandatory principle of accuracy of multi-territorial repertoire information for online licensing. It's Article 26. In my view, this should be interpreted in a way that this information, to be accurate, should be up to date. So it's true that we don't have a direct principle of transparency for these changes in the ownership or assignment of rights, but how can you have accuracy without a proper, day by day? It's a little bit like a stock exchange data. I mean, shares get transferred every day, multiple times. So that's what rights have become in the online market. The conclusion is, successful implementation at a global level of communication to the public, although it's not sufficient in the music sector for reproduction rights. The universal adoption of this right doesn't necessarily mean the battle that should probably be more a cooperation, but business is business, between the music and the copyright holders, broadly defined, vis-a-vis the online platforms, has not been brought to conditions of fairness. Why? Because, in a way, the bargaining power of the right holders is still, especially vis-a-vis big tech, disproportionately weak, and this is what, in our project, we are looking at. I would say it's a kind of interesting that even the most contract law, freedom of contract-based jurisdictions, the most capitalist jurisdiction in the world, that the US had to resort to the measures in the Music Modernization Act, which shows that some corrections to this capitalist and corporate-driven dynamics are probably necessary for the benefit of authors and performers. Thank you.